Today on Legalese, we are going over the oral arguments that just came before the court last week in the two net choice cases that will have massive implications for the First Amendment and social media platforms. Hey, greetings, everybody, and welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, I just want to remind you guys real quick, if you want to find out more about the show, you can go check out our homepage over at illegalesepodcast.com. And if you want to stay up to date whenever I put out any new content, all you have to do is go subscribe to our newsletter over at legaleseshow.com. And I don't just do videos here on YouTube. I also, for one, post to alternative platforms like Rumble and Odyssey, but there's also an audio-only version of the show on Spotify. I also write a lot of articles over on Substack. And if you want to get updates whenever I put out any new content, no matter where or what it is, all you have to do is head over to legaleseshow.com and sign up for our newsletter. All right, well, we have a hell of a lot to get to today, so why don't we just jump right in? So, earlier this week, the Supreme Court would hear oral arguments in NetChoice v. Paxton and Moody v. NetChoice. And these are cases that are challenging the Texas and Florida state laws barring major social media firms from using most types of content moderation, thereby requiring them to host content that they disapprove of. Now, the oral arguments did suggest a clear majority of the justices do believe these laws violate the First Amendment rights to social media providers. They seemed especially skeptical of the government's desire to force traditional social media sites like Facebook and Twitter to change their moderation practices and disseminate speech that they wish to exclude. Now, last week, I released an episode that provided a deep dive into the facts and the background of these cases, as well as walking you through the procedural history to present the information in a way that will be equally helpful to lawyers and non-lawyers alike. Now, that episode will be linked on the show notes page for this episode. And today we will be doing basically the same deal, but only we'll be doing it with the oral arguments that the court heard earlier this week. I have pulled together a comprehensive picture of the information that was presented, and I have pulled out the key moments from the 4 hours of oral arguments. And as always, I will conclude with a summary of not only the possible outcomes, but also my professional, I guess, professional-ish opinion of the most likely outcome in a case that, regardless how it's decided, will absolutely be a landmark in First Amendment jurisprudence. Now, the first thing that really stuck out to me about this session of oral arguments had to do with the questions presented. Now, in our previous video, we did go over the two QPs that the court had granted review on. Now, first was whether the First Amendment prohibits a state from requiring that social media companies host third-party communications and from regulating the time, place, and manner in which they do so. And second was whether the First Amendment prohibits a state from requiring social media companies to notify and provide an explanation to their users when they censor the user's speech. Now, what caught my attention about this is they never actually got around to the second question presented at any point during either session. This was essentially a 4-hour discussion on the issue of content moderation from the first QP. And I realize that may sound a bit boring, but it really actually was anything but. And I know actually there's a lot of law school students who do tend to listen to this show, and I would say if you're interested in First Amendment jurisprudence, or if you're interested in becoming a litigator, you should listen to these arguments because, for one thing, they get into many of the foundational 1L First Amendment cases. I mean, Tornillo, Hurley, Minneapolis Star, PG&E, Salerno, Buckley v. Vallejo. They really do cover all of those cases at one point or another. And furthermore, Paul Clement, and this is something I've mentioned before, I am a very big fan of, was there litigating both cases on behalf of NetChoice. And his arguments in this case were, again, demonstrative of the fact that this guy is really the most talented litigator in the whole of the Supreme Court bar. Now, this case also presented just about as perfect of an on the nose circuit split as you could hope to get. It's really actually quite incredible when you think about it. I mean, if you uh, wrote this up as a hypothetical civil procedure case, it would strain credulity. People would be left asking, how could something like that even happen? Now, as always, there will be links to the full oral argument session, along with everything else that we will be discussing here today, and these can all be found on the show notes page for this episode, and that will include the case briefs, cert petitions, court transcript, case precedent, amicus briefs, and more. So let's start by looking at the oral arguments from the first case that came before the court, Moody v. NetChoice. So in Moody v. NetChoice, the petitioner was the state of Florida, and they were being represented by their state solicitor general, Henry Whitaker. Now, he began his argument claiming that these social media companies were founded as platforms dedicated to freedom of speech, and that after they achieved their success, they effectively betrayed their billions of users by acting as editors exercising control over the content that appeared on their platform. And he claimed this was suppression of speech in clear violation of the First Amendment, and that just like a telephone company, they have no First Amendment right to decide who may or may not use their platform to communicate.
We will hear argument first this morning in Case 22-277, Moody versus NetChoice. Mr. Whitaker.
Mr. Chief Justice, and may it please the Court. Internet platforms today control the way millions of Americans communicate with each other and with the world. The platforms achieved that success by marketing themselves as neutral forums for free speech. Now that they host the communications of billions of users, they sing a very different tune. They now say that they are in fact editors of their user speech, rather like a newspaper. They contend that they possess a broad First Amendment right to censor anything they host on their sites, even when doing so contradicts their own representations to consumers. But the design of the First Amendment is to prevent the suppression of speech, not to enable it. That is why the telephone company and the delivery service have no First Amendment right to use their services as a choke point to silence those they disfavor.
Now, he also made a peculiar and contradictory argument that the power of the state to moderate this content is somehow a regulation of conduct and not of speech.
Broadly facilitating communication in that way is conduct, not speech. And if Verizon asserted a First Amendment right to cancel disfavored subscribers at a whim, that claim would fail, no less than the claimed right to censorship failed in Pruneyard versus Robbins and Rumsfeld versus Fair. Social networking companies, too, are in the business of transmitting their users' speech. Their users are the ones who create and select the content that appears on their sites. The platforms indeed disavow responsibility for that conduct in their terms of service. The platforms do sort and facilitate the presentation of user speech. But this court just last term in Twitter versus Tamina and the platforms themselves in Gonzalez versus Google described those tools as little more than passive mechanisms for organizing vast amounts of third-party content. The platforms do not have a First Amendment right to apply their censorship policies in an inconsistent manner and to censor and deplatform certain users. I welcome your questions.
Now, this actually directly contradicts what the Solicitor General making this argument has said in his petitions, in his briefs filed in support of this case, and we really only need to look to page 3A of the appendix in his cert petition filed by Mr. Whitaker when he was seeking review. Here he says, the very purpose of this law is to prevent big tech companies from silencing conservative voices in favor of expressing a radical leftist agenda. Now, the last time I checked, engaging in speech that expresses a political viewpoint is protected speech under the First Amendment. And to the degree social media sites do perhaps have such a bias, it seems to me that taking an anti-conservative and pro-progressive posture would qualify as a political viewpoint. And yet he wants you to believe that their bill's regulation of a social media's so-called progressive political viewpoint isn't regulation of a political viewpoint.
What's it like to be a liar? Huh? Do you like being a liar with pants constantly on fire?
Objection, Your Honor. Pleading.
I'll rephrase that. Hank, are you a liar?
No, sir. I don't think so.
Yes, you are.
Now, on the other end of things, Paul Clement, the attorney for NetChoice, would respond that it is actually this Florida bill and not the social media companies who are in violation of the First Amendment, and that, in fact, SB 7072 violates the First Amendment several times over.
What's the problem? I haven't got a problem. I've got fucking problems. Plural. Wanna hear?
So, Clement begins by arguing that this law takes away editorial discretion, it compels speech, and it discriminates based on content, speaker, and most important, on viewpoint, and that it does all of this in the name of defending freedom of speech while losing sight of the most fundamental principle of the First Amendment, that it is a limit on state action alone, and that Florida's justification of their right to do this hinges on the facially untrue claim that nothing in the bill is regulating expressive activity. And additionally, he points out that there are at least 3 landmark Supreme Court precedents, and he's speaking here of Tornillo, PG&E, and Hurley, which will teach that you cannot have forced dissemination of third-party speech and then reject considerations of market power, misattribution, or space constraints.
Thank you, counsel. Mr. Clement?
Mr. Chief Justice, and may it please the Court, Florida's effort to level the playing field and to fight the perceived bias of big tech violates the First Amendment several times over. It interferes with editorial discretion, it compels speech, it discriminates on the basis of content, speaker, and viewpoint. And it does all this in the name of promoting free speech, but loses sight of the first principle of the First Amendment, which is it only applies to state action. Florida defends its law, as you've heard this morning, principally by insisting that there's no expressive activity being regulated. That blinks reality. This statute defines the targeted websites in part by how big their audience is. It regulates the content and display of particular websites, and it tries to prevent my clients from censoring speakers and content. If you are telling the websites that that they can't censor speakers, you can't turn around and say you're not regulating expressive activity. It's all over this law, and that brings it squarely within the teaching of Tornillo, PG&E, and Hurley. All 3 of those cases teach that you cannot have the forced dissemination of third-party speech, and they reject considerations of market power, misattribution, or space constraints. And Reno and 303 Creative make clear those principles are fully applicable on the Internet. Indeed, given the vast amount of material on the Internet in general and on these websites in particular, exercising editorial discretion is absolutely necessary to make the websites useful for users and advertisers. And the closer you look at Florida's law, the more problematic the First Amendment problems become. It singles out particular websites in plain violation of Minneapolis Star. Its provisions that give preferences to political candidates and to journalistic enterprises are content-based in the extreme. I welcome the Court's questions.
Now, additionally, the U.S. Solicitor General, Elizabeth Prelogar, was there to represent the federal government's position, and she began her argument in support of the respondents with the point that the First Amendment obviously protects entities that curate, arrange, and present other people's words in an expressive compilation. She said that the court has found this principle holds true for newspaper editors, parade organizers, and web designers. And there she's actually directly referencing those three cases, Tornillo, PG&E, and Hurley. And that there is every reason to believe it holds true for social media in equal measure. She rebuts the claims made by Florida that the reason this applies to social media and not to something like telephone companies is not because there is some kind of common carrier exception to the First Amendment, but rather because a common carriage's whole function is to carry speech from point A to point B, and that they have no First Amendment right to censor because they are not producing any expression of their own.
Thank you, counsel. General Prelogar.
Mr. Chief Justice, and may it please the court. The First Amendment protects entities that curate, arrange, and present other people's words and images in expressive compilations. As this court's cases has held, those principles cover newspaper editors, parade sponsors, and web designers. It also covers social media platforms. Those platforms shape and present collections of content on their websites, and that inherently expressive activity is protected by the First Amendment. That doesn't mean, though, that every business that transmits speech can claim First Amendment protection for that conduct. For example, telephone and delivery companies that carry speech from point A to point B aren't shielded by the First Amendment when they provide that service. But that's because they're not producing any expression of their own. It's not because there's some kind of common carrier or communications company exception to the First Amendment. None of this is to say that social media platforms are immune from government regulation, and governments at every level obviously have an important interest in facilitating communication and the free exchange of ideas. But in promoting that interest, governments have to stay within the bounds of the First Amendment, and these state laws, which restrict the speech of the platforms to enhance the relative voice of certain users, don't withstand constitutional scrutiny. I welcome the court's questions.
All right. And with that, let's move on to the opening arguments in NetChoice v. Paxton. So in NetChoice v. Paxton, the various parties would present arguments that largely focused on how the Texas bill is different from the Florida bill. Because NetChoice was the petitioner in the second case, Paul Clement was the first to give his opening remarks. Now, he began by pointing out that in some ways the Texas bill does have greater specificity, such as the fact that its definitions of social media platform would exclude websites. And this actually spoke to concerns that several of the justices had expressed in the Florida case, saying that it was so broad that it could even be applied to Gmail, despite the fact that that is obviously categorically different from social media. And the other major difference is that the Texas bill also excludes sites primarily concerned with news, sports, and entertainment. And while Texas's brief in this case seemed to highlight that point as though they thought it was a good thing, in that it lacks the issues of overbreadth in Florida's bill that had pretty much every justice had expressed concern with during the first session, Clement, however, would make the obvious point that what that is textbook content-based discrimination, which even Texas agreed is an unconstitutional practice. Now, he would point out that while Texas said the purpose of their bill is to prevent viewpoint discrimination, that we need to consider the fact that viewpoint discrimination is really actually only a bad thing when the government does it. And additionally, he spoke to the fact that the Texas bill explicitly relied on the notion that this is valid as a common carrier regulation.
We will hear argument next in Case 22-555, NetChoice versus Paxton. Mr. Clement.
Mr. Chief Justice, and may it please the Court. I don't want to proceed as if I wasn't here for the first argument, so let me focus on what's different about Texas. One thing, fortunately, that's different about Texas is its definition of social media platforms excludes websites. So we can just put that Gmail issue to one side for when we're talking about Texas. The other thing it excludes, of course, is websites that are primarily focused on news, sports, and entertainment. In the First Amendment business, we call that content-based discrimination. And that's just one of the many reasons that this statute is, dare I say it, facially unconstitutional. The other thing that's different is in some respects this statute operates more simply because it forbids my clients from engaging in viewpoint discrimination. Now, we're used to thinking that viewpoint discrimination is a bad thing and that governments shouldn't do it. And, of course, when governments do it, it is a bad thing. But when editors or speakers engage in viewpoint discrimination, that is their First Amendment right. It is also absolutely vital to the operation of these websites because if you have to be viewpoint neutral, that means that if you have materials that are involved in suicide prevention, you also have to have materials that advocate suicide promotion. Or if you have materials on your site that are pro-Semitic, then you have to let on materials onto your site that are anti-Semitic. And that is a formula for making these websites very unpopular to both users and advertisers. So it is absolutely vital. The other thing that makes Texas a little different is, at least in passing the law, Texas was even more explicit in relying on the common carrier analogy. As if simply labeling websites common carriers makes the First Amendment problems go away. And that is fundamentally wrong for two basic reasons. One, these companies don't operate actually as common carriers. They all have terms of use that exclude varying degrees of content. And second, Texas can't simply convert them into public common carriers by its say-so. I welcome the court's questions.
Now, as I said in my previous video about net choice, both states make this common carriage argument, and both states simply make up their own definition of common carriers, which are entirely inconsistent with the common law definition term that has always held. Now, up next was, once again, the U.S. Solicitor General Elizabeth Prelogar, and she largely spent her time returning to a line of questioning that had taken place between Justice Alito and the Florida Solicitor General Henry Whitaker during the seriatim portion of the arguments in the previous case. And this had to do with the state's claim that social media sites are a common carrier, and Paul Clement replied that they are, in fact, more like a newspaper.
Thank you, counsel. General Prelogar.
Mr. Chief Justice, and may it please the court, I want to pick up with the question that Justice Alito asked in the seriatim round to my friend about the idea that the social media platforms don't perfectly fit into either analogy or paradigm here. And I want to acknowledge the force of that intuition. They obviously operate at a massive scale that goes beyond any particular parade or beyond any particular newspaper. I think the right thing to do with that intuition is to recognize that it's not like you can just exempt them from the First Amendment. They are obviously creating something that's inherently expressive and taking all of this quantity of speech on their websites and curating it and making selectivity decisions and compiling it into a product that users are going to consume. So the First Amendment applies, but I think that those kinds of concerns about how the social media platforms and how they look somewhat different from the other kinds of expressive products this court has reviewed in prior cases can come into the question of whether the First Amendment is satisfied with respect to any particular regulation. Now here we think it's not satisfied because of the way that Texas has designed this law. I'd urge the court to rule narrowly. It's not necessary here to try to figure out how the First Amendment applies to new technology in general or to every possible website or the internet in particular. This law has a very clear defect. What Texas has done is try to countermand the protected editorial speech decisions of the platform, and the only justification it's offered to the courts below is that it wanted to essentially amplify the voice of users on that platform by suppressing the platform's own protected speech. That is a defect that is clear under the First Amendment, and the court could say only that and resolve this case. I welcome the court's questions.
And finally, when the Solicitor General for Texas would present his opening arguments, we pretty much got the kind of absurd, completely nonsensical argument that I would have expected from someone there to represent Texas Attorney General Ken Paxton. This is an attorney who makes Lionel Hutz look competent by comparison.
Now, Mr. Lampwick, when Roger Myers stole your character...
Objection.
Sustained.
Ugh! If I hear objection and sustain one more time today, I think I'm going to scream.
Objection.
Sustained.
Ah!
Mr. Hutz, we've been in here for 4 hours. Do you have any evidence at all?
Well, Your Honor, we've got plenty of hearsay and conjecture. Those are kinds of evidence.
Keep the trial going. I'll be right back.
Your Honor, I'd like to call all of my surprise witnesses again.
They were my favorites.
Now, if you're not familiar with Ken Paxton, you should go and watch my old episode about the Texas versus Pennsylvania case and the absurd, half-assed argument that Ken Paxton made to the Supreme Court to try and overturn the election results in several other states because he didn't like the way they voted, and he felt that that empowered him to disenfranchise their millions of residents. And interestingly, he wasn't even claiming the results were rigged. He really just didn't like the way those states voted. Now, I bring up Ken Paxton a lot, actually, to a good friend of this show who happens to live down in Texas. And every time I do, I mean, I can almost hear her embarrassment coming through in her emails as she laments about how she can't believe this guy keeps getting elected to office. But anyways, going back to the arguments of the Texas Solicitor General, Mr. Nielsen, he starts off with a pretty silly claim about what he says is a past analog involving the telegraph.
Mr. Nielsen?
Thank you. It's been a long day. Mr. Chief Justice, and may it please the Court, this is not the first time that new technology has been used to stifle speech. Telegraphs also discriminated based on viewpoint, prompting a national scandal. Yet under the platform's theory, Western Union was just making editorial choices not to transmit pro-union views. Today, millions of Americans don't visit friends or family or even go to work online, in person. Everybody is online, the modern public square. Yet if platforms that passively host the speech of billions of people are themselves the speakers and can discriminate, there will be no public square to speak of.
But the fact here is that this argument is both absurd and irrelevant. It is absurd because he is quoting a Harvard Law Review article about non-First Amendment freedom of speech. That's the literal title of the article, Non-First Amendment Freedom of Speech. That title alone tells you this article is irrelevant in this case because the only question before the court is a facial First Amendment challenge. Now, furthermore, when you actually read the article, all it actually says is that there were some unsubstantiated rumors about such telephone chicanery.
Only rumors.
I love rumors. Facts could be so misleading. We're rumors.
Now, here is the actual quote from the article he is referencing. It reads as follows. He says, unions, meanwhile, complained that Western Union delayed the transmission of strike-related telegraphs in order to demoralize the strikers and frustrate the plans and confuse the orders of the leaders. So when Mr. Nielsen says that Western Union was making editorial choices not to transmit pro-union views, that statement is both a lie and a logical fallacy. It's a lie because he says that they refused to transmit the message, whereas his source says they merely delayed transmission. And it's a logical fallacy because to say they were making editorial choices not to transmit those views is a textbook example of begging the question. But it gets worse. So, not only does the actual quote itself that we just read sound pretty inconclusive, they said unions meanwhile complained that they had delayed. So they're not even stating a fact. They're saying this is what someone claimed. But so it's Not only does that sound pretty inconclusive and unsubstantiated by itself, but there is a footnote to that paragraph that actually says right in the article that there is no hard evidence any officer or director of Western Union manipulated the country's financial news, stock markets, or labor unions' telegraph messages. And yet he presents this evidence as a statement of fact, when his own source goes out of the way to clarify that this claim is not a statement of fact. And I bring this up because simply none of this augurs well for the legitimacy of his larger argument, that when this is the very best evidence you can bring to bear in a presentation before the highest court in the land, you probably don't have a very good case. But again, I want to point out something I mentioned earlier. It's also irrelevant because social media company, or not social media companies, the telegraphs, they weren't considered common carriers because that's how the telegraph companies chose to identify. It's because they are a textbook example of a common carrier by definition at common law. Now, his cert petition even goes on to suggest that it was because early telegraphers distorted the flow of information that they were labeled as common carriers by the state. He is seriously suggesting that common carrier is a conditional designation based on bad behavior and not a categorical designation based on objective legal criteria, which of course flies in the face of hundreds of years of common law. So it seems Texas believes that you can define things legally based on how you feel most comfortable identifying them. They seem to think that common carrier and publisher are terms that are more akin to gendered pronouns than objective legal terms of art. Really, you could almost call their belief trans-legalism. They personally feel most comfortable using common carrier as their personal social media category identifier, and we all have to just accept their feelings deserve to be treated as objective reality in a court of law. Now, in fact, the very first question that Mr. Nielsen got came from Clarence Thomas, who was calling him out on the stupidity of precisely this argument.
If this was so clearly within a common law tradition, as you suggest, why hasn't Congress seen fit to act as Texas has? And it appears that Mr. Clement suggests that actually Congress has acted in the opposite direction. Would you comment on that?
Now, Mr. Nielsen's next argument is less cartoonishly ridiculous, but it too belies the fact that he really has no idea what he's talking about, and frankly has no business stepping up to the lectern to give his so-called professional legal opinion on a case of this importance before the highest court in the land. So he says that Twitter has gone so far as to claim that they can discriminate against people for reasons other than content moderation.
We know this because Twitter has admitted that their theory of the First Amendment would allow them to discriminate not just based on what is said on the platform, but, quote, on the basis of religion or gender or physical disability. That's not the First Amendment. That's Lochner 2.0.
Now, that first part is what I have to assume to be an intentional misrepresentation of what was actually said, because if we turn to page 146A of the appendices of the Texas petition for a cert, we see what Twitter actually claimed was, quote, they may discriminate against threats of violence made against a person or group based on several factors, including religion, gender, and physical disability, end quote. But above that, it's really his ham-fisted anti-canonical case crab that I take issue with. And Okay, this might take a bit of explaining here, so bear with me. So there is a very common trick that constitutional lawyers like to employ, which is you try to tie your case, try your opponent's case to what constitutional scholars call the anti-canonical body of case law. And these are cases that have been decided are so completely abhorrent that they bear guilt by association. So if you can prove you are arguing against a case that bears any resemblance to one of these cases, the idea is that that itself should count against you. So hence the term anti-canon, or as I prefer to call it in cases like this, anti-precedent, because it goes beyond merely disproving the argument in a given case. This is precedent that actually delegitimizes your case. Now, to understand why this is such an invalid argument, you need to understand the Lochner case. Now, I have made an entire video covering this case in the past, and I'll link to that on the show notes page, but if you haven't seen it or you just need a refresher real quick, here's the gist. So in New York in the late 19th century, the majority of bake shops operated in tenement buildings that were never designed for commercial use, which had serious sanitary issues. And so to address this issue in 1895, New York would pass the Bake Shop Act, establishing a detailed code of sanitary standards. Now, on top of that, at behest of the Bake Shop Union, legislatures also added a maximum hours law that limited employees to working 60 hours per week max. Now, this was done because it gave an advantage to the large union bakeries who could afford to employ shift workers in a way that a small business simply couldn't afford to do. And so Joseph Lochner would sue, arguing that if he and his employees wished to work more than 60 hours per week, that was their business, and they essentially challenged this single provision of the Bake Shop Act, claiming that it violated the liberty of contract protected by the 14th Amendment's Due Process Clause. And the Supreme Court would agree that while the Bake Shop Act's other many health and safety regulations were indeed a valid exercise of the police powers, the majority found that the maximum hours law was a violation of the liberty of contract, and so they struck down that one provision, leaving the rest of the Bake Shop Act intact. Now, personally, I have always been baffled by how that case could be said to have made its way into the anti-canon, among other cases that, for example, declared black people were property, that separate but equal made segregation constitutional. There was a case that said citizens with learning disabilities could be sterilized without their consent, or that American citizens could be detained in literal concentration camps indefinitely without cause or suspicion, where they could be held without due process. But for the purpose of this video, what I take issue with is how nothing about the Lochner case could really said to have any relation to the argument that he is making. So, what does protecting the liberty of contract have to do with a right to discriminate? And I guess what's even more offensive is that there is a much better choice amongst the anti-canon if you wanted to tie your opponent's case to it, and that would be the Korematsu case. Now, again, this may be a little bit complicated, but I'll do my best to explain. So bear in mind, the anti-canon is so small. It's just those 5 cases I listed a moment ago, that the point is not to actually find a case that is a closely related precedent to your case, because those never exist. It is all about a lawyer's ability to make it sound like a closely related precedent, which, as I call it, rhetorical legalism. However, his Lochner 2.0 argument fails on all of these fronts. He didn't even attempt to craft an anti-canonical analogy. He just stated a wildly inaccurate analogy as though it were true. And like I said, if he wanted to make an argument like that, the obvious rhetorical choice was Korematsu. This was the case that had justified FDR's executive actions that, among other things, had instituted the indefinite detainment of American citizens in concentration camps without due process if these citizens just so happened to be of Japanese ancestry. Now, he could have very easily have said that Twitter's comment about excluding people based on gender or physical disability is like the discrimination of Korematsu based on ancestry. And that's because someone's physical attributes, you can remove their freedom to be part of the larger society of Americans, be it online or in the real world. So, I guess that's what really bothers me, is his bad lawyering.
I move for a bad court thingy.
You mean a mistrial?
Yeah. That's why you're the judge and I'm the law-talking guy.
The lawyer.
Right.
So, to Mr. Nielsen, all I really have to say is, I don't know, be better, guy.
Be better. Be better. Be better. Be better. I love that. Just be better.
All right, well, let's move on to talking about what the justices said. And here we're going to be getting into the key points from among the justices during their seriatim rounds. So, Justice Elena Kagan, I'll start with her. She happened to summarize these issues exceptionally well when she noted in the Florida argument that if social media firms have content-based restrictions on what kinds of speech they wish to host, like keeping out what they consider misinformation or hate speech or bullying, she asked, why isn't that a classic First Amendment violation for the state to come in and say, we're not allowing you to enforce those kinds of restrictions, even though it's like an editorial judgment and you're excluding particular kinds of speech?
I just want to sort of understand your position, and I want to narrow this to the paradigmatic social media companies, sort of news feed postings, Facebook, YouTube, Twitter /X. So suppose that that I say, just take this as a given. All right, you can argue with the facts, but don't. Suppose that I say, for the most part, all these places say we're open for business. Post whatever you like and we'll host it. But there are exceptions to that, and clearly content-based exceptions, which the companies take seriously. So let's say they say we think that misinformation of particular kinds is extremely damaging to society. Misinformation about voting, misinformation about certain public health issues. And so, too, we think that hate speech or bullying is extremely problematic. And so we are going to enforce rules against this. If they're only going to apply to a small percentage of the things that people want to post, for the most part, they're open for business. But we are serious about those content-based restrictions, all right? So in that world, why isn't that a classic First Amendment violation for the state to come in and say we're not going to allow you to enforce those sorts of restrictions, even though, you're basically, it's like an editorial judgment. You're excluding particular kinds of speech.
Well, Your Honor, I think I take your hypo to be assuming that it's First Amendment protected activity, and I think that what you would do in that instance, you would have to run intermediate scrutiny under Turner, and the analysis regrettably.
So don't say what I take it to be First Amendment activity. I mean, do you take it to be First Amendment activity?
No, that's our whole point. I mean, again,
even though they're saying, yeah, we are a big forum for lots of messages, but not for those kinds of messages. We want to exclude those kinds of messages. Why isn't that First Amendment a First Amendment judgment?
I mean, I think the court held otherwise, I think, in Pruneyard, because there was an editorial policy against leafleting, too. And again, I don't
No, that was just about leafleting, and the mall owner didn't have any expressive views. I'm taking as a given that these, the YouTube or Facebook or whatever has expressive views. There are particular kinds of expression defined by content that they don't want anywhere near their site.
But I think, Your Honor, you still would have to look at the objective activity being regulated, namely censoring and deplatforming, and ask whether that expresses a message. And because they host so much content, an objective observer is not going to readily attribute any particular piece of content that appears on their site to some decision to either refrain from or to censor or deplatform.
Do you think so as to this? This is a real-world example. Twitter users one day woke up and found themselves to be ex-users, and the content rules had changed, and their feeds changed, and all of a sudden they were getting a different online newspaper, so to speak, in a metaphorical sense, every morning. And a lot of Twitter users thought that was great, and a lot of Twitter users thought that was horrible, because, in fact, there were different content judgments being made that was very much affecting the speech environment that they entered every time they opened their app.
Your Honor, respectfully, that does not answer whether they have a message in their censorship, any more than, I'm sure people objected, again, quite strenuously to the fact that the law schools were permitted to interview on campus. I'm sure people wanted to ban leafleting at the mall in Pruneyard, and that does not give them a message in that. And I think the reason for that is if they are not carefully selecting the content in the newspaper, they don't have a message in the mere existence of the content on the site.
Thank you, General.
And Justice Amy Coney Barrett would actually go much further with this same argument, trying to understand why this wouldn't constitute editorial control.
Excuse me.
Okay, well, put aside common carrier for 1 second and just common carrier to the side. Just tell me why this doesn't look like the same kind of editorial control we see newspapers exercise.
Because the platforms do not review. It is a strange kind of editor, Your Honor, that does not actually look at the material that is going on its compilation. I mean, in Twitter versus Tamina, the platforms told you that they didn't even know that ISIS was on their platform and doing things. And it is a strange kind of editor that does not even know that it's the material that it is editing.
Is it because it's not humanized? I mean, human eyes, not human eyes. Is it because it could be an algorithm that says, we want to have, Justice Kagan was pointing out terms of service, we want to have this kind of site. Or some say that, for example, TikTok might have boosted pro-Palestinian speech and reduced pro-Israel speech. That's a viewpoint, right? And if you have an algorithm do it, is that not speech?
Well, it might be, Your Honor, but again, in Twitter and Gonzalez, the platforms told you that the algorithms were neutral methods of organizing the speech, much like the Dewey Decimal
Well, that's not
system.
what they're saying here. So let's assume that what they're saying here, that they're organizing it, in ways that reflect preferences, that are expressive of their terms and conditions. In that event, do you think it would be editorial control in a First Amendment sense?
No, and I think it's less.
Well, let me just interrupt you there. I mean, Justice Sotomayor pointed out that even though there may not be physical space constraints, there are the constraints of attention, right? They have to present information to a consumer in some sort of organized way, and that there's a limited enough amount of information that the consumer can absorb it. And don't all methods of organization reflect some kind of judgment? I mean, could Florida enact a law telling bookstores that they have to put everything out by alphabetical order and that they can't organize or put some things closer to the front of the store that they think, their customers will want to buy?
I think first, let me just take a step. Sting and censorship.
Okay, so your argument that it's not expressive entirely depends on the hypothesis that the sorting and feed functions are solely some sort of neutral algorithm that's designed to user preference and that they reflect no kind of policy judgment based on the platform itself.
No.
Now, Chief Justice John Roberts would similarly emphasize that the First Amendment restricts what the government can do. And what the government is doing here is saying, you must do this, you must carry these people, you've got to explain if you don't. And he says simply, that's not the First Amendment. And in fact, Brett Kavanaugh would join the chief in making a very clear state-private First Amendment distinction.
Justice Kavanaugh?
In your opening remarks, you said the design of the First Amendment is to prevent suppression of speech, end quote. And you left out what I understand to be three key words in the First Amendment, or to describe the First Amendment, by the government. Do you agree by the government is what the First Amendment is targeting?
I do agree with that, Your Honor, but I don't agree that there is no First Amendment interest in allowing the people's representatives to promote the free exchange of ideas. This Court has recognized that as a legitimate First Amendment interest in the Turner case and all the way going back to the Associated Press case.
Well, in the Turner case, the intervention was, the Court emphasized, unrelated to the suppression of speech, the antitrust type intervention there. So I'm not sure when it's related to ensuring relative voices are balanced out, or there's fairness in the speech or balance in the speech, that is covered by Turner. Do you agree with that?
No, I don't agree with that, Your Honor. Our interest in our
What
law—
did Turner mean by unrelated to the suppression of speech?
Well, we don't view our law as advancing interests that are related to the suppression of speech. We think that the interest, for example, in protecting journalistic enterprises from being censored, from MSNBC being censored because an Internet platform doesn't like a broadcast it showed on its station the other day, that is just an interest in preventing them from being silenced. It's not an equalizing interest. It's giving them a chance.
On the editorial control point, you really want to fight the idea, and I understand, that editorial control is the same thing as speech itself, and you've emphasized Pruneyard over and over again. But we have a whole other line of cases, as you're aware, of course, Hurley, PG&E, Tornillo, Turner, which emphasize editorial control as being fundamentally protected by the First Amendment. And I understood the line between Pruneyard on the one hand and those cases on the other to be whether you were involved in a speech communications business as opposed to a shopping center owner, which is the other side of the line. Can you respond to those cases?
And another clear distinction just about every justice skeptically addressed at some point was the social media as common carriers claim, and rightly so. Chief Justice Roberts addressed this distinction in terms of market power.
Sorry, go ahead, Chief.
This may be the same question that Justice Gorsuch was asking, but does the nature of the economy at issue matter to us? I mean, the social media platforms, the Internet, all of that stuff, an incredibly dynamic market. The government, maybe not so much. And yet it's sort of a inflection point to say that the government has the authority by categorizing the members, the participants in this dynamic market as common carriers to take over extensive regulation of them, not with respect to communication, but all sorts of things. I mean, when you're talking about railroads or telegraphs, it's not just moving transportation. It's what the railroads look like, what the safety things they have to have, a whole range of things that, in the Wild West economy surrounding the social media platforms and the Internet may be totally inapt. Now, I don't know if it comes at a time when you need to make that transition or not, but that is a very big step when it comes to the extent of government regulation.
Now, on the other hand, Justices Jackson and Sotomayor would express a different and, I would say, arguably even more important defect in this common carrier argument. While they both reject the common carrier argument itself, they further elaborated that even if it was true, the social media platforms could properly be designated as common carriers, that still wouldn't give the states the vast power of oversight and regulation that these laws would prescribe.
Not like those. And
but
why
doesn't it depend on exactly what they're doing? I mean, I guess the hard part for me is really trying to understand how we apply this analysis at the broad level of generality that I think both sides seem to be taking here. You say what is being regulated here is conduct, not speech. Well, I guess maybe if you're talking about Facebook's news feed feature, but there are lots of other things that Facebook does that that might be speech, but then there might be other things that Facebook does that doesn't qualify as speech. So don't we have to like drill down more in order to really figure out whether or not things are protected?
Actually, I don't think so. I think that precise ambiguity strongly favors our position, Your Honor, because in the posture of this facial challenge, all you need to look at is whether there are at least some activities.
No, but no. I guess what I'm saying is you mentioned the Pruneyard case, or the Fair case, excuse me. I mean, we didn't say that law schools, as a categorical matter are, always engaged in unprotected speech. We looked at the particular thing. This was a fair, and, the law school was saying we don't want these certain entities in it. I hear you suggesting that we can just say, Facebook is a common carrier and therefore everything it does qualifies as conduct and not speech. And I don't think that's really the way we've done this in our past precedents, okay?
General, I think I'm finally understanding the argument, but let me make sure I do, okay? When I came in, I had the reaction Justice Alito did, which is we should vacate and remand. And I have been thinking about what does that do to the preliminary injunction, because I agree with you. As I understand what the state did below was to say we don't have to offer you any justification for any part of our law, because everybody of these social media companies are common carriers. And I think what's clear is, from our questioning, that that's not true, that there are many functions that are expressive that we can't say are common carriers. But even if we did say they were like common carriers, the issue would be one of what's the level of scrutiny. And the state said there's no level of scrutiny we're going to address. They basically said we can do anything we want to common carriers and to any of the expressive platforming or deplatforming things. But I don't even think that's true. They can't come in and I'm not sure they can, do any of these things or some of these things, even to common carriers if it is a sort of content or viewpoint, content exclusion. So a common carrier doesn't have to permit unruly behavior, doesn't have to can throw somebody off the train if they're threatening somebody else or if they're doing other things. So I guess what you're saying is let's keep the injunction in place, vacate and remand, affirm on the preliminary injunction, but vacate and remand on the application of this law and how, based on what level of scrutiny given the function that's at issue, correct?
So we do.
And furthermore, Justice Sonia Sotomayor would emphatically and repeatedly state that these two state laws are, quote, so broad they stifle speech just on their face, end quote. And importantly, she asked at what point a law like this becomes so overbroad that it actually becomes the duty of the state to justify the constitutionality of the law, rather than the duty of the individual to justify the unconstitutionality of the law.
This statute, a plainly legitimate
speech. This is such a odd case for our usual jurisprudence. It seems like your law is covering just about every social media platform on the internet. And we have amici who are not traditional social media platforms, like smartphones and others who have submitted amici brief telling them that readings of this law could cover them. This is so broad. It's covering almost everything. But the one thing I know about the internet is that its variety is infinite. So at what point in a challenge like this one does the law become so generalized, so broad, so unspecific, really, that you bear the burden of coming in and telling us what exactly the sweep is, and telling us how there is a legitimate sweep of virtually or a meaningfully swath of cases that this law could cover, but not others. When does the burden shift to the state when it writes a law so broad that it's indeterminate?
And I think the takeaway from that particular line of argument was that she clearly seemed to believe that wherever this line is, these laws have went well over it. Now, Samuel Alito and Clarence Thomas were the two justices clearly most sympathetic to the states in this case, and they would repeatedly characterize the social media content moderation as censorship. And Justice Brett Kavanaugh would very effectively, I think, respond to this trope. It pains me to call any argument by Clarence Thomas a trope. God knows I love that guy. But if I'm being fair, that's precisely what this is. And really, Brett Kavanaugh came in with a surprisingly poignant and substantive retort.
Just pick up on the word censorship, because I think it's being used in lots of different ways. So when the government censors, when the government excludes speech from the public square, that is obviously a violation of the First Amendment. When a private individual or private entity makes decisions about what to include and what to exclude, that's protected, generally, editorial discretion. Even though you could view the private entity's decision to exclude something as, quote, private censorship.
Absolutely. That was the whole thrust of this court's decision in Halleck. And I suppose the Hurley case might have been a completely different case if that was an official City of Boston parade and the City of Boston decided to exclude the group. The whole reason that case came down the way it did unanimously is because it was a private organization exercising its First Amendment right to say we don't want glib in our parade.
All right. It's time to discuss outcomes and conclusions. So let's first just discuss the possible outcomes for this case, given the totality of information that we have. Now, it's all but certain that the court will strike down these laws. They easily have at least 6 votes to overturn, maybe more, but as always, there are a number of possible ways they may go about dealing with this case beyond simply striking down the laws. Now, in the Florida case, several justices suggested that they might not be able to uphold the lower court ruling against the law because that state's legislation is so broad that it may cover websites that aren't even expressive in nature at all, such as Uber or Etsy. And if the court vacates the lower court decision on this basis, the case could be remanded and the plaintiffs might have to amend their complaint to turn it into an as-applied challenge that would focus more specifically on social media firms that exercise editorial discretion. Now, Justice Sotomayor suggested that they might remand the case, but also leave the preliminary injunction in place in the meantime. Now, these kinds of procedural issues were much less significant in the Texas case, where the law in question is more clearly focused on big social media firms. Thus, the Texas Supreme Court could, not the Texas Supreme Court, the Supreme Court could potentially vacate and remand the Florida decision, but rule against Texas. And in this instance, the precedent set by the Texas ruling would govern any future litigation in the Florida case and challenges to similar laws that might be enacted by other states. And finally, there was much discussion of the issue of whether the tech firms' plaintiffs' arguments that they are exercising editorial discretion somehow undermine their exemption from liability for posting user content under Section 230 of the Communications Decency Act. Now, to my mind, this issue really isn't before the court, and frankly, it makes me a little nervous that Justices Gorsuch and Thomas, and to a lesser degree Justice Alito, actually spent so much time trying to go down the Section 230 rabbit hole. This risks the possibility of taking attention away from the only issue of importance in the case, as it is the only issue before the court, and that is whether or not this law constitutes a facial violation of the First Amendment.
So that's a complicating feature on a facial challenge. But here's another one for you. What about Section 230, which preempts some of this law? How much of it? And how are we to account for that complication in a facial challenge?
Oh, well, why don't you answer the question, then we'll
Briefly.
move on.
Yeah.
Well, I think that the court should answer the question presented, I guess.
But how can we do that without looking at 230?
Well, because I don't think that there's any, some of this was briefed at the cert stage, Your Honor. I don't think that the Section 230 C2 preemption question is really going to dispose of the case. The district court actually reached the Section 230 issue, but concluded that it still had to reach the constitutional issue anyway.
I'll get back to this in my turn. Thank you. Just wanted to give you a chance to finish up on the Section 230 point. I think it's Section 6 of your law that says that the law is not enforceable to the extent it conflicts with Section 230.
Sure.
So
Sure.
Why wouldn't we analytically want to address that early on in these proceedings, whether in this court or a lower court?
Well, the law
does that complicate our attempt to resolve
Sure.
things in a facial challenge?
Sure, Your Honor. And I think that the reason is because the law is not facially at least preempted under 230C2, which principally regulates takedowns.
And I just wonder how we're supposed to deal with that fact, if I agree with you, in this facial challenge context, and particularly when many of the platforms, while reserving the right to prohibit various kinds of posts, most of which are consistent with Section 230, also say and guarantee users a right to express their ideas and opinions freely. I'm quoting from one of them. And even if the platform disagrees, and they say that they do not endorse and are not responsible, again, I'm quoting from some of these terms of service, sure sounds a lot like conduit, doesn't it? That their terms of service also include the right to exclude certain speech, but those are usually like the Section 230 things, the way they discuss it, the lewd, lascivious, obscene, blah, 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 blah. And after that, they do seem to promise a whole lot of latitude. And expression of the user is theirs because they curate it. Where does that leave Section 230? Because the protection there, as I understood it, and Justice Thomas was making this point, was that Section 230 says we're not going to treat you as publishers so long as you are not, it's not your communication in whole or in part, is what the definition says. And if it's now their communication in part, do they lose their 230 protections?
Now, I do want to point out here that there really is actually no contradiction between the First Amendment protection for moderated content they choose to remove and the Section 230 exemption from liability for content that does appear. And with that said, I predict the holding will be a solid win for the First Amendment, though the procedural complexities of this case might see that win roll back slightly at some point if the Florida litigation of their case is remanded. All right. Well, that's really all I have for you guys today. Thank you so much for tuning in and checking out the show. If you would please take a minute and do those things for me that help to trigger algorithm, I would appreciate it. Hitting that like button helps a whole hell of a lot to make sure other people see this video. So if you would, if you liked it, hit the like button. If you disliked it, hit the dislike button. I'm not asking you to lie here, but I prefer a like. Make sure to subscribe to the channel so you always get notifications whenever I put out new content. There are a lot of other cases coming up. I'm going to have to be doing a case on Garland v. Cargill here soon, as well as the Murphy v. Missouri and some others. So to make sure you don't miss those, make sure you subscribe to the channel. Definitely leave me a comment. Let me know what you thought about this video, this topic, this case. Just share any of your thoughts. I always love to hear what you guys think about the topics we discuss. And I guess until next time, all that's left to do is sign out. So this has been Bob for Legalese. talking about the First Amendment and social media, and of course, as always, Carthago delenda est.